classmates. Today I am here to present the topic sources of international law under Hindu personal law paper of Mr. LL.B. BHU. My topic is sources of Hindu law. So this PowerPoint presentation of 18 slides, we will go through different sources of Hindu law and what has emerged from these sources, the Indian jurisprudence of Hindu law, and then after different other particular slokas and all will be discussed meanwhile. So let's first discuss what is this Hindu law. So Hindu law, if we go to the definition, a lot many Western jurists like Austin and Maine have described law in a different form. For example, Austin has described law in a different form and Maine has described. So definition of Hindu law, this is the body of rules governing Hindu personal and family affairs. So those who are Hindu or those persons who belongs to India and follow either Hinduism, Sikhism, Jainism, Buddhism, all those people will be governed by this Hindu law. And this law is also lex sposi law. This is not a lex sposi law. If a person is a Hindu and he is residing at some other place, then also that person will be governed by this Hindu law. So it is irrespective of the place where the person is residing. So in this, marriage, divorce, adoption, maintenance, succession, inheritance, guardianship, these all, the provision of all this is included. So our this Hindu law, before being codified in 1955 and 1956, the Dharma, Shruti, Smriti and custom were the sources, and on the basis of that justice was given. Judgment was given on the basis of that. So from that sources only modern law, modern codified law, Hindu Marriage Act, Hindu Succession Act and all has been codified. So in this one main term is their Dharma. Okay. So this Dharma is a very wide concept. We can say law is equal to Dharma, or interchangeably law can be called as Dharma. But Dharma is a very wide concept. It can be superset of all the law. So this Dharma is a very wide concept. It is a superset, and on this subset is a law. Apart from law, or a lot many things are there in this Dharma. So Dharma can be, as of now, interchangeably used for law. Dharmo Rakshti Rakshita, this is a particular portion of a sloka from Mahabharata that will be discussed at the later of this PPT. So what is Dharma?
What is the difference between Dharma and Kartavya?
Dharma and Kartavya. Kartavya is particularly related to what one person needs to do. That is Kartavya. But Dharma is the inclusion of a lot many things. What should be done, what should not be done, what our religious text, the different sacred text tells us to do and not to do. It is also related to the subconscious, superconscious or the spiritual portion of our mind. So it is a very wider concept. Dharma is a very wide concept, and instead of telling at some place Hindu as a religion, we can. So being part of Banaras Hindu University and being taught by such a respected professor, we should at least change the Hindu religion into Hindu Dharma. As religion is something very concise. For example, it is related to particularly one sect, one path, one textbook, or one particular God, or the form of version of God that the person worships. So this Dharma under his righteous duty and conduct. If a person is on his righteous duty and conduct, he is following Dharma. Along with that, moral, social order, righteous duty, conduct, moral and social order. This all is included in our Dharma. If we are not following our righteous duty, for example, we are in this class, our duty is to study. We are not following that, we are doing something else. We are doing some anti-social activities in our society. That is against our righteous duty. Conduct, how we interact with the person, what is our behavior. That is our conduct. Again, moral and social order. This moral can be changed from time to time and place to place. What is moral at some place can be immoral at some other place. Social order at some place we can have a particular conduct that is beneficial for our future or for our interest, but that can be not beneficial for our society. So that social order should also be maintained. Again, we discussed this is broader. Dharma is a broader concept. It includes law and then foundation of classical Hindu legal order. Whatever we are having now as a codified law, that is on the basis of this Dharma. In our parliament or the committee which was responsible for constitution, making or framing the constitution, there also particular debate was done on this term Dharma. What is Dharma? So let's start our presentation. So first we will bifurcate the different sources of our Hindu law. Before this, we are having one particular slope. Veda Smriti Sadachara Swasya Ja Prematmana Etaj Et Chaturvidam Tahu Sakshat Matsya Lakshmana. So this Vedas, Smritis, approved custom and Indian conscience. These are four direct sources of Dharma. This is mentioned in Manusmriti chapter 2, sloka number 12. So there it is mentioned that these four are the direct sources of our Dharma. Veda, one by one we will go through different sources. And if we bifurcate the different sources, so before 1955, when Hindu law was codified, before this ancient sources were there, and in ancient sources we are having Shruti, Smriti, commentaries and customs. One by one we will discuss each one of them. And in modern era after 1955, we are having four different sources. Now we are having precedents, we are having PT, we are having legislation and statutory domains. So one by one we will go through each of the sources of Hindu law. The first one is Shruti. It is the revealed knowledge. It is said that Shruti came from the root word Shru, means which was heard. Heard by whom? Heard by it was not heard by normal people. The sages who was beyond this physical world, who attained most sacred and superpower, those were heard by them and those came into existence as Shrutis. So these are the direct revelation of ancient rishis. Means one who attained enlightenment, one who attained a lot many knowledge of beyond physical existence. So in this Shruti we are having Vedic text. We are having four Vedas, Rig Veda, Yajur Veda, Samved and Atharvaved. These three Vedas. We are having first three Rig Veda, Yajur Veda and Samved as the earliest Vedas, and later on the name of Atharva, Rishi Atharva, Atharva Veda was also added into the Vedas. So these are the foundational hands. In Yajur Veda and Samved, ritualistic formulas and the music, what we are having Sangeet nowadays, that has been derived from Samved, Sa Re Ga Ma Pa Dha Ni Sa. These came from this Samved, and a lot many other things are also there in Samved. Otherwise, practical social rules are there in this, and in these 4 Vedas, it is further sub-categorized. The 4 Vedas are further sub-categorized. Okay, so these 4 Vedas is again classified into 4 different sections. One is Sanhita, okay, the actual hymns and mantras. Next one is Brahmanas. Brahmanas means the explanation of that Vedas. Then we are having Aranyak, and then we are having the explanation of Vedas into Upanishad. We are having 108 Upanishad, and these Upanishad are philosophical in nature, explanation of Vedas. For example, out of 108, not all Upanishads are very beneficial for these sources of Hindu law, but 10-12 Upanishads are there, which actually deals with the law. One Upanishad is there, that name is Mandukya Upanishad. It is related to philosophy. A very small Upanishad, around 2-3 pages are there, and in that Upanishad you can find the question of who am I. So apart from the law, we can go into the depth and know ourselves. In that Mandukya Upanishad, it is mentioned what we are physically available here into this world. This is also not, we are not also this. If we are in sleep, deep sleep, and we are thinking of something else, or we are at some other place. Okay. So this Upanishad is philosophical. It is. Next one is Smriti. Second ancient sources is Smriti. So that Shruti was heard by the rishis. Okay. So that came into existence as Vedas and all. But at that time, some portion of that particular means hearing was not means captured. Okay, it was not remembered at that time. So later on that was remembered, and then that came into existence as a Smriti, which was recollected. Means again that was recollected, and that was collected in form of Smriti. Here one more slokas is there, that is from Smriti, chapter 1, sloka number 7. Shruti Smriti Sadachara जब हे महात्मना सम्यक संकल्प कामो हर विधम स्मृतम. Shruti Smriti, virtuous conduct and inner satisfaction form the root of Dharma. So Shruti that we deal with in the last slide, Smriti the other portion, okay, Dharma Sutras, and virtuous conduct, the right conduct, our conduct, behavior, and then the inner satisfaction. People say we are having universe in our mind. So what is right, what is wrong, what is good, what is bad, that can be assessed with our mind. Okay, so this inner satisfaction forms the root of Dharma. So in this Smriti we can further classify as Dharma Sutras, Dharma Shastras. Dharma Sutras is in the form of prose. Around 800 to 200 BC it was written down, and some of the example of Dharma Sutras are Gautama, Udayana and Vasishtha. Then Dharma Shastra is in the poetic form. It is in the prose form. The example of Dharma Shastras, Manu Smriti, Vyasvalika Smriti, Narada Smriti, and different other Smritis are also there. But these two, Manu Smriti and Vyasvalika Smriti, are the main source of Hindu law for today. Next, commentaries and digests. So these all texts were in Sanskrit, and it was very ancient. We don't know who wrote this. So different other person who was having the knowledge of that Shrutis and Smritis, they came with commentaries and digests. They studied that, went to the depth of that knowledge, and they wrote down in their own terms. Okay, according to the situation, the contemporary situations. And then after then after two schools, Mitachara school and Dayabhag schools came into existence. It is on the basis of the area, okay, geographical area. So this Mitachara school, this is in existence of all over India except Assam and Bengal. In Uttar Pradesh, Madhya Pradesh and different other parts of India follow this Mitachara school. In this school, the ancient property goes into the hand of the higher. Okay, higher. So except Bengal and Assam, it is followed all over India. So by birth only the right property right arises. If a person, if a particular child was born in a family and then after he was separated due to any circumstances, then also by birth only the right of the property goes into the hand of that child. This Dayabhag school, it is followed in Assam and Bengal, and in this ancestral property right, it goes into the higher names after the death. Or we can say that if a particular person who is doing the rituals or the last sanskar of that particular person, then the property can go to that particular person. Then the fourth one is customs, sadachar. It is long established usage of taking the force of law in a family, locality or caste. Now if suppose thousands years back Vedas, Shrutis, Smritis were written. Now we need to have particular some judgment or justice into a particular case. Now the situation has changed. Different circumstances are there. So how will that be justified? How the judgment will come? So on the basis of that, we are having customs. If suppose a particular custom is being followed at some place, so on the basis of that, justice will be given, and not on the basis of text that was written earlier. It is also mentioned in the Smriti. If suppose there is some clash between the text and the custom, then at that particular place, custom will prevail and not the text. So in this custom, 4 different characteristics should be followed. In order to call a particular practice as custom, requisites are there. First one is antiquity. Antiquity means it should prevail from a long time. A long history should be there of that. Continuous usage beyond memory means it should be practiced from a very long time. Second is certainty. It should be uniform and it should be uniform and unambiguous. Means it should be uniform all over the place, and it should not be ambiguous. It should not be in contradictory to some other uses or customs. Next one is reasonableness. While in public policy, people should accept that. And the next one is statutory compliance. No conflict with 1955 Act. So if suppose some customs are there and it is in contradiction with the different act passed in 1955 and 1956, so it will not prevail. Our statutory act after our modified act will prevail in that. Next one is customs overriding rule. In a particular case, collector of Madura versus Moto Ramalinga. In this case, dispute regarding widows and adoption without explicit husband consent lying on regional private practice was there. Actually, a particular woman was there and she was a widow. Then after her son got married and he also got his son, means the particular woman got grandson. Then that woman wanted to have adopted son and gave his property right to that particular son. So it was held in this. The right of property to the widow can also be restricted. If suppose the lineage, means particular family son got married and then again he got his heir. Okay. So at that particular point of time, the right of widow can also be restricted. So Privy Council judgment came and clear proof of usage will outweigh the written text of law. The particular written line of Smriti was given by the Privy Council at that time. Now, judicial precedents, model sources of Hindu law. So different case laws are there. Sastri Yagna Dasdi versus Vimukh Das. It came in 1966. In this case, Swami Narayan temple, there was a dispute for entering of Harizan in Swami Narayan temple. The particular person wanted only the satsangi to be there in the temple. Although those satsangi were also from the Dalit community, but they wanted only the person who followed the satsangi to be there in their temple. So it came to the court, and then after Supreme Court gave its judgment, and in that judgment, Supreme Court judgment, it was told that Hindu law is a dynamic and inclusive. Sect falls within Hindu boundaries and state reforms laws apply. Gujarat state passed at that time on law, and on the basis of that there should not be discrimination by following any sects. So this Swami Narayan and the follower of this satsangi, they can't respect the other person who are not satsangi, but according to broader sense of the term Hindu, every person who follow the customs of Hindu, they are Hindu, and since it is dynamic and inclusive, the restriction of non-satsangi was overruled, and the entry of other Dalits were also given in Swami Narayan temple. Next one is equity, justice and good conscience. Its application is when personal law takes statutes and customs are silent, means when there is no law for a particular act or particular issue, then this equity, justice and good conscience will come into force. The judges, the particular person who is sitting as a judge, he will use the Swami versus Bradappa. Courts utilize the equitable principle to prevent unjust enrichment of property distribution. In this case, under Hindu Shastri law, under this, widow had a spiritual right to adopt a son to continue her deceased husband's lineage. However, Supreme Court ruled that this power is not absolute and can permanently be extinguished. In some situations, the right of that widow can also be restricted. Now, landmark cases that this collector of Madura versus Ramalinga and Satyapati 1861 case was discussed. Then we are having Thakur Bhopal versus Parveen Kumari 1952. In this judgment, a custom must be ancient, certain and reasonable and must be proved by evidence that the different requisite of custom we saw in last slide. Then we are having Gurunath versus Kamla. In this, when no clear rule or custom exists, court may resort to justice, equity and good conscience that we nearly last slide. And D. Chinnamma versus Ramaswamy in 1978 it was held that a customary practice must satisfy legal requirements before it can displace the general rule. So legal requirements should be there. It's suppose now parliamentary legislation. So in 1955 and afterwards different act was passed. Hindu Marriage Act 1955 came into existence, and the marriage of Hindu is in this act. Hindu Succession Act, the property right is there to this Hindu Succession Act 1956.
ये succession पे है
Now legal order hierarchy, this is just before 1955 when it was not codified, the primary sources were Smriti is Commentaries and Custom. After 1955 we are having statutory acts that we did in last fight. Then the status of custom, it overrides written text initially, but now valid only if expressly said. Overriding. Evolution of jurisprudence. These are